Good morning, everyone, and welcome to the Michigan Negotiators Association. We have a session today, critical points of bargaining, and very excited to introduce our guest speaker today, Mr. Bob Schindler from Miller Johnson. And Bob is a longtime friend of the Michigan Negotiators Association, and so glad to have him with us today to talk about the critical points of bargaining. And Bob is a graduate of Eastern and Michigan State College of Law. And as we know, he certainly spends a lot of time with us at MNA and MASPA and other groups around the state of Michigan, and has been very involved with the educational sector. And he's known throughout the state as a school law attorney, but he's also a speaker, as we're going to see. He's an author. And he's a teacher. He teaches, he's an adjunct professor at Oakland University and their educational law program. So education, obviously a longtime passion of Bob's, as he was a teacher out of the gate and then got into the law side of this. But certainly his bigger passions are his family. And with that, I'm going to turn it over to you, Bob, and really appreciate you being with us. And thanks everybody for being here and joining the Michigan Negotiators Association this morning. And Mr. Bob Schindler, thank you.
Thank you, Kelly. I appreciate it. And yes, I appreciate having MNA host and have me out to speak. Here in this virtual world, this is about as good as we can do at this point right now. Doing it like this online. I wish we were all together in Lansing to talk instead of doing it this way, but you do what you can when you can, I guess, right? So good morning, everyone. As Kelly mentioned, today we're going to talk about critical points of bargaining. And the way I think of this presentation is I like to really look at not just sort of talk about some of the basics of bargaining, but really more importantly, getting into some of the strategy and considerations that you need to think about both before the contract and then in the process of the bargaining as well. Things to think about, strategy considerations, things to prepare yourself and your team for, and when and where you can, you can really look for opportunities and critical points where maybe it's easier to get a contract settled at times. So without any further ado, let's get going then. All right. So what are we going to talk about today? A couple of things as far as the basic flow of this presentation. One, we're going to talk about the basic flow of bargaining. Bargaining tends to follow a process. Not all bargainings are the same, but there tends to be a natural flow that happens, and we're going to talk about that a little bit. We want to talk about understanding the dynamics of bargaining and what goes into that, what we can do to prepare, and how we can be better suited for it, and then your communications plan, and that's going to be about how you communicate with all of your stakeholders that are involved in bargaining, because what we often see is that bargaining is a rather public thing, that sometimes it isn't just the teams who are at the table who are having an influence on this, or sometimes folks who are at the table are trying to use other parties to bring influence on the process. And so we're going to talk a bit about that. All right, so understanding the flow of bargaining. Time is your friend. It's funny, I've watched this as PA 54 has sort of changed the bargaining process. It used to be that we were the ones trying to get to the table and the union was dragging their heels. And that's changed over the years post PA 54, because there are certain things about time that make it imperative. Most importantly, like expiration of the contract means there can't be any raises, means that any increases in health care get borne by the association members, the union members. And as a result of that, it's usually now the union who are trying to get to the table a little faster, and we're the ones who are in no rush anymore. So the bargaining process, though, does have points of time that create leverage, that being one of the biggest ones. But we'll talk about some other ones. These points in time will create opportunities for a deal, for a bargain, to get it done. What we see is that oftentimes you have your dates on your calendar and you bargain, but there are certain points in time when bargaining speeds up and intensifies and accelerates. And that's good. You want to use those points, understand that those points in time are coming, and do your best to use them so that way you can address the issues and try and get a deal done. Use those pressure points. So what do those include? So if you think through the natural bargaining process, right? So one of them is the end of the school year, right? I mean, if you're bargaining your teacher contract, a lot of those teachers probably have summer plans and who are on the bargaining team. And those summer plans probably don't include wanting to come in and bargain. Now, maybe the virtual bargaining that we're in nowadays makes that process a little bit easier. When we used to have to come into the building and all bargain sitting around a table, it would be like, well, I'm going to be up north that week and I'm going to be here that week. So getting the work done by the end of the school year is one that usually is a pressure point. They would prefer to not take their time over the summer, right? The expiration of the CBA is another big one, as I mentioned before. The start of the new health insurance contract benefit year is one. So this is one, obviously, a few years ago, the MEA and MESA kind of got on the offensive about, right? This used to be that your health insurance benefit year went from July 1 to June 30. That has changed now, right? They made those changes a few years ago. So now that it runs January 1 to December 31, and they gave all kinds of reasons as to why that was. But of course, the real reason was PA-54, because those contracts run up at June 30 oftentimes, or in August maybe, depending on your contract. And the reality is they wanted to give their members 6 months to be able to get that deal done before there was a problem. First payroll of the year. This is often a big one, and this is even, the expiration of the CBA is one that can be a problem in terms of PA-54, but the reality is that PA-54 really won't kick in from a pay raise standpoint until the first payroll. So while the contract benefit or the contract expiration is significant, in practical application, it won't actually hit until the first payroll of the year. All right, so the start of a new school year is also one. Again, as students are coming back, teachers are beginning to work. That's another good point to try and get things done. And so the likelihood, another final one is that the likelihood of impasse or pressure of impasse breaking techniques may also help spur a deal. Things like mediation, or fact-finding as an example. Not necessarily even that fact-finding occurred, but that fact-finding may occur or is upcoming can sometimes help spur a deal rather than going through that process. All right, so understanding PA-54, PA-152, and their importance. So we talked a little bit about PA-54, and if some of you on the call are sitting here going, I don't know what PA-54 is, we'll get to that. And we'll talk a bit about it. I know sometimes as lawyers we throw around things like PA-152, and if you haven't been around since 2011 in the HR world, you're probably thinking, I don't know what that is. And so these are two really important statutes that come about from the bargaining context, and are both part of the now part of the Public Employment Relations Act, or the PARA, as you'll often hear it called. So PA-152 was a statute passed back in 2011. That this is the hard cap statute, right? So it requires that either districts, it creates a default hard cap, or a district can choose for all of its employees to be an 80-20 district, meaning the district pays 80% of the cost, and employees pay 20. If you are going to be an 80-20, the board has to adopt a decision on that before July 1, or your medical benefit plan coverage year. And again, it applies to all employees, you can't just do a bargaining unit. Remember that the way that PA 152 operates is it creates this hard cap, and that hard cap is a ceiling, meaning the employer shall pay no more than the hard cap. So in terms of negotiation strategy, you can always negotiate in, for example, your own specific hard caps that are less than the statutory hard caps. It's just this is the ceiling of what it is you can pay when it comes to employee benefits. Room for creativity here if you need more concessions or different things as a result of that. And then one point I always think is important to make is that if you want to bid out insurance, it requires advanced time and planning. If you want to change insurance, this is something that is going to take time as well. I have said that I don't think I've ever had a situation where, without having discussed the changing of insurance in advance, where I've proposed a change of insurance at the table and it's actually been accepted by the other side. One of the things we know is that insurance is one of those areas that people tend to have almost an emotional response about. And so if you want to change insurance, again, this is something that you need to be thinking about, if that's an area of cost, and talking this through in various different ways, whether that's through a benefits committee with your unions, whether that's just simply having educational sessions as you bid things out in advance. It's important to get them thinking about it and buying in on potential changes in advance. So that was PA 152. PA 54, again, another term that's thrown around a lot. That's another statute that also came about in 2011. And what PA 54 says is that after expiration of CBA and until a successor agreement is in place, a public employer shall provide wages and benefits at levels and amounts that are no greater than those in effect on the expiration date of the CBA. So CBA expires June 30. Whatever wages are in effect at that time, that's what stays in effect unless and until there is a successor agreement. That includes steps, that includes lanes, that includes longevity as well. And this is something that oftentimes, especially if you're in concessionary bargaining, you will see unions will try and negotiate for sunset clauses on those concessions, for example, or on freezes. Have them expire the day before the contract expires or sunset before it expires. Watch out for those. I will tell you that I've negotiated and put sunset clauses in contracts before because it was a situation where we were getting a pretty significant concession that was needed, and we didn't want to do the sunset, but it was something that the union was going to hold on tight to in order to give the concession. So you have to, again, that's sort of that give and take that you have to consider when it comes to whether or not you're going to do it. But it's something to think about and watch out for when it comes to PA 54 and what it means and its effect. Because if you do that sunset, you're giving away a real point of leverage that you're going to have in the bargaining when that next contract is up. Employees who receive health, vision, prescription, or other insurance benefits under CBA shall bear any increased cost of maintaining those benefits that occur after the expiration date. Doesn't apply to all fringe benefits, but it does apply to those listed. Another point is that any money you give cannot be retroactive, meaning if you don't settle your contract until mid-October, you can't say everyone's getting steps and it's retroactive to the beginning of the year, because you didn't have a contract at that point. You can't go retroactive. Now, I know that districts and unions have talked about all kinds of different potential workarounds for this, whether that's a signing bonus or something else. I think, if those sorts of proposals are going to be made, you can consider them, but you need to be careful in terms of what you're talking about, how you're talking about it, what's in the language, and what it looks like, because in the end, you don't want to violate the law. All right, so what has PA-54 done to bargaining? Well, I think it has changed the process, as I've mentioned. I think it's gotten more intense and generally shorter bargaining durations. It used to be that it wasn't uncommon that you saw contracts, bargaining go for maybe an entire school year after the contract had expired. You see a lot less of that now. It still happens on occasion, but you don't see it very often now as a result of PA-54. If there's money for steps and lanes or salary increases, it's made those looming deadlines very important. It's gotten bargaining to speed up. Again, I think especially that first payroll of the year has been a real point where bargaining tends to get settled now as a result. If not, PA-54 keeps a district from digging a deeper hole. But if substantive economic concessions are needed, PA-54 does not carry districts all the way past the finish line. Meaning, it does help, right? If you're in a bad economic spot, PA-54 stops steps from happening, and so it allows you that opportunity to sort of breathe and bargain that contract without having to worry that steps are going to happen and you're going to have this fiscal cliff. Of course, if you need concessions, if you're in, a deficit and that deficit is growing, PA-54 probably isn't going to get you there in and of itself, but it is an aid that you can have. Assess how. So you have to think about, again, when it comes to bargaining, I can sit here and I can talk about bargaining strategy, but the reality is bargaining is going to be different in every district in some way or another. So you need to think about, for your own district, what it looks like, what PA-54 is going to do for you, and how you can use it, right? Can you wait out your contract resolution indefinitely? Because, hey, if with PA-54, if we get a freeze, we're good, right? It's actually going to allow us to maybe bank some money and we'll be okay. So that's going to affect the urgency with which you bargain and the ability to withstand some of the pressure that the union may put on you. If you're in a situation where you can make it through one more year with a freeze, then good. If you're in a different spot where if you don't get concessions soon, you're going to be in trouble, then you have to have a fallback plan. That PA-54 won't be enough, and you have to be prepared for what concessionary bargaining may look like. We were at the point at the beginning of last year where I felt like most school districts were getting on the real positive side economically. We had so many economic problems for so long after sort of the Great Recession that it took a while for some districts to dig out of it. And it seemed like in the last year or so, everyone was taking a breath. And then, the coronavirus came and sort of took all that away from us, and now all of a sudden we're trying to figure a lot of things out when it comes to economics. And so maybe you felt as though you were on steady ground, and now you're not sure. You've lost students, and maybe the Superfund has helped you this year, but next year you're looking at problems or your potential. So you need to think about all those pieces when you're bargaining and what it is you really need. Think about that in advance and use these statutes. The legislature has given you tools with these statutes, so you need to use them to your advantage. So understanding the dynamics, understanding what the dynamics are between union and management, and especially in your district, right? In many ways, bargaining is about relationships. The ability to communicate your positions with the other side, with your board, with your community, what levels of understanding and trust there are. A lot of those things are going to matter when it comes to your collective bargaining process. In some cases, they may not matter as much as you think, and you may think you have a good relationship with the union, and all of a sudden you're not understanding why things are going south the way they are. But you need to know sort of how all the pieces work together and what those relationships are, and don't assume things. Get ahead of the game when it comes to communication. If you don't understand those dynamics, again, you'll be more vulnerable to union tactics and will not be able to depersonalize the attacks to think objectively about an effective counter strategy. Also, if you don't understand the available tools, you'll be reluctant to use them. So again, you want to inform yourself on bargaining and be prepared. I'm a firm believer in the idea that the best way to bargain is to be prepared in advance for bargaining. And so if you don't want to sort of figure it out once you get to the table, you want to be prepared and have everything in your head, think through strategy in advance. So that way you can adjust your strategy as the process goes, but you want to have all this stuff thought through in advance. As far as this depersonalization goes, I think this is an important point. I think a lot of times people who get involved in bargaining are surprised at some of the sort of the personalized rhetoric that comes along with bargaining oftentimes. And, we as a management side have an advantage in this sense in that we're able to depersonalize it more. When we engage in bargaining, we have the ability to look at the district as a whole, and each bargaining unit is just a piece within that whole pie. And we look at the unit as a whole and what it's going to mean and what it's going to cost us. For those bargaining unit members, this is their salary, it's their benefits, and so for them it's a much more personal thing. Also, their unions know this, and they use that personal issue, that emotional issue, in terms of stoking up their members and riling their members to try and get the best deal that they can as well, because they want to use that emotional advantage. So we have to understand that and know that we can, depersonalize it. And when when the other side tries to make it more personal, understand that that is part of the process. Take a deep breath and step back a little bit from it, because the more I think we stay professional, the better off the process is. Think about the big picture, right? So what are the possible final outcomes in negotiation? Generally, right? Either you get an agreement or you don't get an agreement. Eventually, you have to have something, I suppose, a contract in place. And I don't know any district who's ever been able to function without a contract forever. So eventually you'll get an agreement, but maybe it'll come with more time and process. If you can't get an agreement, like an actual agreement without having to force hands, one of two things is going to happen, right? The board will either implement its last best offer, meaning an impasse, or maintain the status quo indefinitely until an agreement can be reached. When that happens, when that bargaining drags on, the union will increase its efforts to change bargaining goals through either electing or recalling board members or through more pressure in one way or another. So we have to understand that the longer bargaining goes, the more likely the union will attempt to put pressure outside the table, away from the table, on board members individually, through community communications and the like. So understand if you have bargaining you think is going to go for a while, it's important to understand that. And it's important to get the board on board with this early. Make sure they're informed and letting them know. We're going to talk more about sort of that communication strategy as we go here, but that's an important piece. And so what we often see generally is while we're bargaining, we sort of are working on dual tracks, right? We're at the table, we're working to reach an agreement and position the board to exercise its options under the law, right? You have your formal table positions. You have to be prepared for things. You have informal positions where the board can go, meaning you're thinking through that process and knowing, okay, here's where our table is. Here's maybe where our bottom line is. Away from the table, you have to be able to sort of counter the union's pressure tactics and efforts to elect or recall board members, meaning you have to prepare the board and administrator for for this process, and develop a communications plan, setting the climate and communicating key messages. So as you're at the table doing these things, you have to be away from the table, keeping your people informed, your bargaining team, your board of education, keeping them informed on what could happen, what to expect, what is going on. They're going to hear things from the community. They're going to hear things from the union president, and you need to be making sure that you're in their ear as well, and they're not just hearing the other side. One of the things I've seen throughout my legal career is that there is nothing a board of education hates more than feeling blindsided about something. And so when the union president comes to a board member and starts telling them about all the awful things that are going on at the table, if you've already been talking to them, that's going to be helpful. They're not going to feel blindsided by that process. All right, maintain a positive mindset. Right, the board has all the tools needed to accomplish its bargaining objectives. Over the course of the last decade, the legislature has really helped school districts when it comes to prohibited subjects of bargaining, when it comes to PA 54, when it comes to PA 152, all of these different things. We really do have, from the management side, kind of the upper hand when it comes to strategy in bargaining. Now, and that's why oftentimes the union will use as a strategy the emotional aspect and putting pressure on boards and the like. So we have to understand that we have those tools available, that then it's about managing the conflict to be able to emerge from the bargaining process victorious, I suppose we'll say. Although usually when you get a contract done, it never feels quite like victory because there's some back and forth on it, right? But you want to use those tools in that process. And part of that, especially if you're the chief bargainer, is maintaining a positive attitude through this. Bargaining can be long, bargaining can be exhausting. And at certain points, the other side understands that. And the hope is that through the bargaining process, you'll wear out and just say, fine, I'll give you this, or we'll give you that. So you have to maintain that positive attitude for you and your team to really work through that process. All right, next, planning objectives and managing the process. Before I get to that section, I do have a question that came in. It says, I'm new to a small district. 2 board members have always sat at the negotiation table. Every board member is related to a staff member. I have never heard of this before. What are your thoughts on this? Thank you. So my thoughts are, one, it's not that uncommon in a small district to have a situation where 2 things. One, where people are related, board members and staff members, and 2, that that board members sit on bargaining teams. Now, as far as my thought on that goes, I am not a fan of having board members at the table if you can avoid it. In the end, the board members are the ones who vote to ratify the contract. And so the truth of the matter is, if they're sitting at the table, the union is going to focus their attention on them. Even if they're not the chief spokespeople, they're just sitting to the side. Every argument is going to be tailored toward them. They're going to be talking at them. Even if they're not looking at them, that's going to be their message is toward those individuals. And I think it distracts from the process and makes it less objective. Now, in some cases, you may not have that option. Your board may insist on it. But the truth of the matter is, if you can avoid it in any way, I think you can. If you're new to the district, some of that may be about, sort of your influence in that district and whether you're able to tell the board that you think it's a bad idea. And that, again, can also depend on sort of the dynamics. As far as they're related to a staff member, Again, that's not uncommon. It is going to change, the ability to vote on the contract depending on that relationship, but it's not that uncommon. In small districts, there's often a lot of relatives within the district employed and between the board and the employees, and so it's just a dynamic you're going to have to learn to figure out. There are some things that you can talk to your counsel about in terms of, whether or not those board members should even be in closed session at all or anything like that when it comes to bargaining discussions. But that's kind of a bigger topic a little bit. All right. Preparing the board for the end run, right? So before bargaining is even begins, the board should be consulted to review objectives that the board wants to achieve, right? So you need to understand where the board is at. You need to prepare the board for the realistic possibility of achieving the objectives, and that should be candidly discussed with the board, right? So if, for example, you're a district where you're just above the 5% threshold right now, and it depends on what you're looking at. Is the board's objective to keep you above 5%, or is their objective to build fund balance and get it up to 8%, right? So one, you need to discuss with the board what those objectives are and understand their position. Understand how realistic it is. What kind of time frame are we talking about? Are we talking about that we want to get 8 to 10% within the next 5 years? Or are they saying we want it now? And help them to understand the fact that, as a school district, the only place you really have, or the biggest source as far as your dollars go, is your labor, right? In the average school district, 70 to 80% of your total overall budget is going to be in labor. And within that 70 or 80%, 70 or 80% of it is going to be within one bargaining unit, and that's your teachers. So, the reality is, if you're looking to cut costs dramatically, there's not a lot of places we can go. So the board, you need to have those conversations. The board understand where they're at, understand how hard line they are about it, and talk to them realistically about ways to get there. These discussions are not intended to, put undue influence, but prepare it. Again, prepare it for what is to come. That if they're going to really hold the line hard on one thing or another, especially if we're talking about, a freeze where you've had freezes for 7 years in a row, or you're talking about, a 5% decrease in salaries, they need to understand that this is going to create pushback that may result in the union claiming they're going to try and recall the board or do different things, that this could be aimed at them as well. And if they're good with that, then good, move forward, but understand these points and move forward with it. A question has come in that asked if I or MNA have a prohibited subject of bargaining summary sheet. So one point is actually in this PowerPoint, we list off all of the prohibited subjects. There is also, if you go to the Michigan Legislature's website, and we'll talk a little bit more about this, there is you can find the statute. Statute number is MCL 423.215, which is the statute that has all the prohibited subjects in it, and that actually lists them all out exactly what they are. But the person who asked the question, I can try and touch base with you later on as well. All right, effective management of negotiations. So there's more to bargaining than just simply legal or other things, right? There is a lot in terms of management of negotiations that are important. There's the legal, there's the practical, there's the emotional preparation of the process. And it's important that the board, the superintendent, central office, building principals, and the community are all involved in sort of managing those expectations. And so, part of that process is to have a clear vision of the necessary outcome and a commitment to it, and to communicate those goals. And it's also really important that, and this can be hard in a lot of districts depending on your board dynamics, but it's important, and it's important for the board to know, and for your central office and building management to know, that the negotiation team has to be the one who is the voice for negotiations. And that if there are questions, if there are concerns, things need to go through the negotiation team. This, again, can be hard for board members in particular, I find. They've been elected, they feel a duty to the community, and so they want to be able to talk about these things. But what we see practically is the more voices there are out there talking about what's going on in bargaining, the bigger mess you can get into. It also is a situation where unions will find people who they believe they can have influence over, and make sure that they've talked to those people. And so the likelihood is the more board members, or if you have a superintendent who's not at the table, or your building principals, the more that they're willing to engage in conversations about bargaining, the more the union's going to go to them. And so they need to be prepared for that as well. And what I always tell board members, for example, when I talk to them, is the best thing you can do is when someone comes to you to talk about bargaining, you can listen. You can smile and nod your head and say, thank you for letting me know. And then you can say, I'm going to talk to X, whoever your lead negotiator is, or I'm going to talk to the negotiation team about this. Thank you for your input. But not try to solve the problem or explain the problem or anything like that, because that tends to lead to issues. And it's important that we are in the ear of those other people in advance and consistently throughout, reminding them of that fact. Establish a regular procedure to review negotiations with the board. So it's important in this process that you don't just talk to the board in advance and then let it go, but instead have regular meetings, updates, establish a regular procedure to review with the board the progress of negotiations in light of ongoing developments, modify as needed the district strategy or bargaining parameters. If things change, parameters can change and the bargaining can change. All of a sudden you expected your student count to remain flat. The school year starts while you're bargaining and you've lost, 2% of your students. All of a sudden now your bargaining process is going to change. And the union's going to scream that's regressive bargaining, but the situation has changed and you need to change along with it. But regular meetings with the board to discuss the progress of negotiations is essential to maintaining board support for the bargaining strategy jointly developed by the administration and the board. So it's important that process is continued. So have a normal process, stick to it. That helps to create predictable and consistent method of conducting reviews, to talking about the issues that arise. And the reality is your strategy may change, but talk through that as well, right? So for example, let's just say you have, in your monthly regular meetings during negotiation, because you have 4 open contracts, you may be sitting there saying, okay, every board meeting, we're going to have a negotiation strategy closed session, just to keep the board updated on what's going on. And maybe as bargaining gets more ugly, you're going to add into the agenda a negotiation update in public session and not in closed session, where you won't talk about strategy, but you'll at the very least update the board as to what's going on, proposals that have been made, etc. That can sometimes be done because in the bargaining process, we may think that the bargaining unit members and other people, the community, they're hearing only one side of the story, and that one side doesn't reflect what our reality is. And so, maybe then we modify our strategy and we say, okay, we're going to do these updates in open session instead of just in closed session. That's okay. Unions don't like that, and they'll tell you that oftentimes they'll tell you that's not legal, that you can't quote unquote bargain in public. But there is no actual prohibited subject for bargaining in public, so long as you're giving facts, and we're going to talk more about this. So long as you're sticking on facts, that is 100% legal. All right. So in terms of this preparation, you're going to need to first prepare your bargaining team. So who is going to be on the bargaining team? Well, one, you're going to need to choose a chief negotiator. And who to choose as the chief negotiator can vary. In some districts, I've seen it where that's the superintendent, in some it's the head of HR, in some it's the business director, in some maybe it's outside counsel, and that can vary. There is no set rule on this. It can be anyone. The board should choose somebody who, they believe has some skill and experience in dealing with this issue in labor negotiations, and that they believe has both the influence and the personality to be able to handle the situation and do it well. I think sometimes you need to think about the personality dynamics, right? If you're head of HR and the union president, sort of get along like oil and water, then maybe it's not a great idea for your head of HR to be the chief negotiator, because there may be conflicts involved. So you need to think about these things. There may be compelling reasons to consider someone outside to do negotiations. Understand that if you have someone from the outside, that will probably become an issue. You will hear at some point at the table the union say things like, well, you don't have money for raises, but you have money to pay the lawyer to sit here and bargain. I understand how that goes, right? At some point, they may FOIA the legal bills or the bills of whoever you have, you have something like MASB in there. They'll FOIA that as well to see what it's going to cost. I've seen everything from, advertising it. We had, I know of one district where the union actually paid for a billboard that put, legal fees up there that associated with bargaining. So understand that could be an issue, and that there still may be a compelling reason. For example, I've worked in districts where they've never had someone from the outside bargain before, but I've come in to bargain because they knew, it was going to be a difficult bargaining process, or they were in a transitionary period where they had a new superintendent, new HR, and they wanted to have some consistency when they're going through that process. There are many different reasons why it may. It may be that, maybe that you have a good working dynamic between HR and the union, but bargaining is going to be tough, and you don't want to sort of sully that relationship. And so having somebody else be there to be the face of the ire of the union is a good thing. So think about those points. Generally, smaller bargaining teams operate more efficiently than large ones. So, I've been at the table where the union bargaining team is like 12 people. I never like to operate with a team that large because, it's too many cooks in the kitchen. The more people at the table, the more conversation is going to devolve. And so I find that smaller teams are generally more efficient. I always think 3 to 5 is a good number, and then going from there. But your separate dynamics can matter. It can also be, too, that your bargaining team doesn't have to always be consistent every time, meaning you may have, if I'm bargaining, let's say me and the HR and business director as the bargaining team. But if we're talking about, classroom sizes one day, I may want to have the high school principal there or the head of curriculum there for that bargaining session. They don't have to be a member of the team always in order to be at the table. So if we're talking about a topic and we know we're going to talk about a topic, we can let the union know, hey, by the way, I'm going to have the curriculum director here for the next session because I want to talk about this class size issue. And that's okay. They can just do that and come in, for one meeting or for another. All right, multiple proposal options. When we're bargaining, right, you never start with sort of your last and best. Generally, there are some exceptions to that rule, but generally speaking, that's the reality. And when you think through what it is you want in this contract, you have to understand that likely isn't what you're going to get, right? So you have to identify alternatives when it comes to the bargaining process. You need to prioritize your goals in the process. When you're preparing, collect alternative samples and ideas. Groups like MNA are great to be able to network with people, to talk about what they've done in their contracts, to get ideas, and really sort of begin to formulate options, things to consider. Determine again whether the time is on your side, right? Will time help you or hurt you in this process? And use that for your strategy. Oftentimes I think it's good to not think of bargaining as in individual silos, right? So we're bargaining this year and we're going to get this contract done and then we worry about the next contract. No, think about playing the long game, right? So we're bargaining for this contract, but we have an overarching goal, right? If the goal is to keep fund balance, if the goal is to grow fund balance, if we're in a great place and we're going to spend down a little bit of fund balance, what does that look like, right? If you have a board goal of 8 to 10% on your fund balance and you're sitting at 15 right now, the union's position is going to be, awesome, you have 5% to spend right now. And your position may be, well, we're willing to get down to 10, but we don't need to do it all right now because we need to think about this in the long term. We want to spend down over the course of the next 3 to 5 years to get there, maybe, right? So think about that process as a whole and how that affects this current bargaining, and whether you're going to do a multi-year contract or 1 year or the like. And assess your crisis mode. What is the likelihood of a crisis? What does that look like? When will that happen? And be prepared for it. Prioritize proposals. So think about what's necessary, what's nice, what's necessary, and what's sort of your drop dead, right? So if it's a matter of a crisis mode, is it a situation where if you don't get concessions and get them quickly, you're going to go into deficit, like not just below 5%, you're going to go into deficit? I've been in some districts where I was bargaining in a district one time where if we didn't get concessions and get them quickly, we were literally worried that we weren't going to be able to cash the checks, right? So it had gotten that bad at that point, right? So understand what's really necessary, what's a high priority, what is, hey, this is something that we would like to get, but we may not, and life goes on. And what are things that, as I call them here, fodder, right? Things that, hey, this is aspirational. I'd love to get this, but it's not likely. But you know what? I'm going to put it into our bargaining because in the end, it's a bargaining chip we may use at some point down the line. That's okay. Think about those things in terms of how bargaining is going to work and where you want to start and where you need to be. Consider other things and whether or not they're a distraction or if they have trade value, right? Insurance, as I mentioned before, can often be very emotional of an issue. So you have to think about whether or not you want to even propose changing insurance, or whether that's going to so distract the process that it's going to make it harder to get the job done. Snow days. This is one that has been a big point of conversation recently, right? Are snow days a thing of the past, given sort of our current online environment? Do we want to bargain away, maybe instead of having, you know, an unlimited number of snow days or up to 6, that we want to say, hey, we're only going to have 2 snow days in the contract where you don't have to work and you get paid. And after that, we're going to go online. Is that something that you want to put into a contract? Is it something that makes sense? Is it going to be distracting and emotional? It's probably something that the unions can make an issue out of, even if it isn't the main issue, because it could be emotional for your community. So think about those things and the value of what it is you're proposing, not just economic value, but the value as a whole in the process. And then through that process, you're going to develop sort of a hierarchy of your proposals, right? What's your initial proposal? What's your compromise position? And what's your bottom line? So I give an example here of an actual bargaining that I did, where we had a district that was in really rough economic shape at the time. And we came to the table. Our initial position was we needed a 12% on schedule reduction for the entire bargaining unit. In our minds, our compromise position was a 10%. It wasn't as good as we wanted, but it would help us. Our drop dead, our bottom line that we ended up coming down to was a 9% off schedule reduction in pay, and that's where we actually settled the contract. You know, but think, and you can go in the reverse, right? If you have money to give, it can be the same thing, right? You're going to come to the table with steps and you know, $1,000 off schedule at the top step, but you know that you're willing to maybe give steps and some on schedule money. All right, so what does that look like? How do we get there? And, you know, think about, plan in advance. Well, here's where I think we should start, and here's our drop dead. Here is our last and best. Know that in advance before you even make that first initial proposal. Again, same kind of concept, right? Know where you want to wind up, know when you must be there, and how you're going to get there. Develop that plan in the process. All right, so calendar and prohibited subjects. I'm going to talk a little bit about this. All right, so calendar and prohibited subjects of bargaining. So we're going to talk a little bit about what the prohibited subjects are, what they mean, and calendar is always one of these issues that comes up and gets tricky, right? Can we bargain calendar? To what extent? You know, what if the year's coming up and we want to get started in the school year and we still don't have a calendar yet? What does all that look like? It's often a point of stress. People want a calendar published. I've had administrators tell me, Bob, it's almost April. We have to have our calendar published for next year. And I'm like, no, you don't. Not yet. Obviously, we would like to. You may be getting phone calls because people are trying to plan their vacations and they want the calendar. But you could function without it for a little while. One of the benefits, though, that you have going here is they want the calendar too, right? The teachers also want to plan their vacations. They want to know what days they have off and when. So this is a point where they're going to want the issue as much as you are. It's just a matter of sort of holding on tight to some of it. The legislature and MDE is often changing rules that also make it more difficult on you, right? You can use, as I put here, a couple of those issues that have come up over the last few years, right? You can use PD as student hours. No, you can't. Yes, you can. And now we're in the state where you can use that, right? 180 days and 1098 hours. And then it was, well, okay, forget the 180 days. It just has to be 1098. And then, of course, a couple of years ago now, they went back to it. No, let's do 180 days after all. So they make your job more difficult sometimes on that, but you can work through that. And calendar can work on a little bit of a separate track, right? You can work through that calendar. And what the case law on this says is that you can get the calendar early or impasse early on calendar because of business necessity. So while you may not have a situation where you're at impasse on wages or health care or other issues, you can get there with calendar beforehand because, hey, in the end, people have to know when they're going to work. So it may be a situation where you can implement a calendar in August while you're still negotiating over the other things. But also it's important to understand that the notion that you need a calendar sometimes is overblown anyway, right? The reality is you have a calendar. When a contract expires, the status quo remains in effect unless and until a successor collective bargaining agreement has been reached, which includes calendar. So if the contract has expired, status quo for calendar stays in place as well, which means as so long as your calendar this coming year looks similar to last year, that's going to remain the same for the same number of student days, approximate same number of same time for breaks and for number of breaks and so on and so forth. You do have the unilateral right to set the first day of school because that's a prohibited subject of bargaining. And it's important to understand that status quo does not mean it has to be the exact same thing, right? It doesn't mean September 4th has to be the first day, etc. It has to be substantially similar, and there's some case law on this one if you're at that point on this one. But it doesn't have to be the exact same when it comes to that calendar. All right, prohibited subjects. So as I mentioned, prohibited subjects are listed in the para, and I give the site here, MCL 423.215. So if you want to see this list sometime, you can go to the Michigan Legislature's website. They have a pretty good website where you can, pull down statutes and the like. If you put in this number on the MCL search 423.215, it'll come up with a statute that has all of these. Examples of them include things like 1249 evaluation system. That's a prohibited subject. Your 1248 policy regarding personnel decisions, teacher placement, experimental or pilot programs, contracting for non-instructional support, though you must give them a chance to bid. These are all things that are prohibited subjects. Under law, they are treated similar to illegal subjects. So what I mean by that is the PARA, the Public Employment Relations Act, was designed after the National Labor Relations Act. And the National Labor Relations Act doesn't have prohibited subjects. We decided to create this concept in the 90s. Legally speaking, what other bargaining statutes have is illegal subjects, and our courts have said they're basically treated the same. An illegal subject is something to say, if you agree on this, it can't be enforced because it's illegal, right? So meaning if we decided in a collective bargaining agreement that we could discriminate against someone because of age, let's say, for example, and we put that in the contract, well, that wouldn't be enforceable because it would be illegal. And so the prohibited subjects are treated the same way. Section 15 of the PARA specifically provides collective bargaining between a public school employer and the bargaining representative of the employees shall not include any of the following subjects. And then it goes on to list them. And then afterward it says, the manners described in subsection 3 are prohibited subjects of bargaining between a public school employer and a bargaining representative of its employees, and for the purposes of this act are within the sole authority of the public school employer to decide. So it's a pretty strong statement, and it's an important thing to understand. Those are matters that we have sole exclusive right to decide, and that the legislature says that we should not be bargaining over them. PA 112, originally created, this is 1994 PA 112, so this one goes back, created 9 subjects of prohibited bargaining, and then back in 2011, we had a really big change in terms of school legislation in general, and at that time they added a few more, and then in 2012, a year later, when the Freedom to Work statute, or Right to Work statute, as we often call it, was passed, it added another prohibited subject. So I do list them out here as well. These are the original prohibited subjects from '94. There are a few of them that are important. The school starting day as an example. The subcontracting of non-instructional services. One point, and this is one that I think will come up very big over the next couple of years as we sort of look at this new world that we're in, doing some remote learning, and whether we want to keep some of our virtual academies that we may have, or whether we want to negotiate, for example, again, over snow days, and whether we're going to do virtual days instead on those. One of those that's been in place since 1994 is the use of experimental or pilot programs, or the use of technology to deliver educational services and programs. And that second half, it doesn't have to be experimental or pilot. If it's the use of technology to deliver educational services and programs, that is a prohibited subject. And what the statute actually says is it's that, or the impact of that decision on an individual or the bargaining unit as a whole. So again, as we're looking, let's go back to that example of the snow days. We don't have to bargain over whether or not we're going to virtually have school on a day when it's not safe to get the students to school. Instead, we could potentially use this use of technology to deliver instruction prohibited subject. If you think about what it is that we bargain relative to snow days, what we're actually bargaining is the fact that they don't have to work and they still get paid for it, right? That's what we're bargaining. We don't make them come into the building. That's the bargaining aspect. Here, we're just having them work in a different scenario in terms of the use of technology to deliver instructions. And so I think that could become a very important one over the next several years when we're looking at some of what comes out of this coronavirus world that we're in now. Again, in 2011, they added some more teacher placement, 1248 personnel decisions, the layoff and recall and that sort of thing, 1249 evaluation systems, teacher discipline and the discipline standard that we use for teachers, classroom evaluations, merit-based comp under Section 1250, and the like. And then in 2012, violations of the Freedom to Work statute also became a prohibited subject of bargaining. Real quick, in looking at some questions, I have one that asks, if a district pays for employees' dental and vision and the contract is not settled at its expiration, is the employee now responsible for the cost of dental and vision, or only health insurance? No, this is one differentiation, right? So PA 152, which is the hard cap, only applies to health care and does not apply to dental or vision. But PA 54, when it comes to the employee bearing the cost of the increase, is not limited to health care. What this statute actually says is health, dental, vision, prescription, or other insurance benefits under a collective bargaining agreement. So any increase that occurs after expiration of any of those insurance products that are negotiated as part of the collective bargaining agreement would would have to be borne by the employees rather than the employer. All right. So getting back to the prohibited subjects, what does it mean to be prohibited? And we talked a little bit about what the statute specifically says, right? That these are things that shall not be bargained and are in the sole authority of the employer to decide. Our courts have been even more specific, right? Making clear that any provision in a collective bargaining agreement covering a prohibited subject is not enforceable. So even if you chose to bargain over it and put it in the contract, that wouldn't be enforceable. Either party may refuse to continue or carry over within a new contract any existing provision pertaining to a prohibited subject, and that a school district is free to act unilaterally regarding those topics. So again, when it comes to carrying over, and we'll talk more about this in terms of removing prohibited subjects if you still find some in your contract, but you don't have to quote unquote bargain them out, right? If you have them, you can let them know we are refusing to put this into the new contract. We're not carrying it over because it's prohibited subject. Either party in negotiations may refuse to even discuss those prohibited subjects, although you can voluntarily discuss them. But you can say, hey, look, we're bargaining right now. We're not going to talk about that. That's a prohibited subject. We don't want to get into it. You can talk to me about that some other time, right? Public employer may act unilaterally. Neither party may maintain one to impasse. Any provision in a collective bargaining agreement covering a prohibited subject is not enforceable, and either party may, again, refuse to carry them over. These are all the real aspects of what a prohibited subject means. If in your review of your CBA, look for prohibited subjects. I always recommend, before you get to the table, before you make your first proposal, do an audit of your contract. Read through it. It's not the most exciting reading you're ever going to do in your life, but give it a read cover to cover. And in that process, one of the things you look for, you're going to look for language that maybe doesn't make sense. You're going to look for things where you read and you're like, I don't even know what they're talking about here. And you're going to look for prohibited subjects. And so if you find them, you're going to want to remove them from your offers to the other side. It is likely many of the obvious ones have been removed already, but in this process, there was a time when when we would look through these things and we would think, well, maybe this is prohibited, maybe it's not, and maybe now we have answers. So there may be things that are still sitting in your contract that are prohibited and that just haven't been touched since 2012. So give it a look and figure that out. This often occurs. One of the biggest ones that I see out there that are still in contracts are limitations in some way or another on teacher placement. And they won't be super specific, like saying, hey, here's how, how voluntary transfers work or involuntary transfers, but maybe it's just simply notice, right? Before you involuntarily transfer a teacher, you have to provide, 30 days notice. Well, that's part of the procedures of that teacher placement, and so that too is prohibited. And when you tell the other side that it's prohibited and you're striking it from the contract, they're going to say, wait a minute, what's wrong with notice? What do you have against notice? Nothing, but it's not part of the contract. We'll provide notice, but we're not going to put it in the CBA, right? Other examples, again, must notify a teacher of a parent complaint or limitations relative to investigations. That's a common one I see in contracts now. And when I often talk about this at the table and I say, I think this is prohibited, they say, no, it's not. This is a procedure, or it's something else. And then my response is always, okay, well, to what result? If I don't follow this and you grieve it, what's your response going to be? Well, the response is going to be that the investigation needs to get thrown out, or that you can't discipline the person as a result of it because you didn't provide them the response in time, or this or that. So that's what I often focus on is, okay, well, let's spin this out to the end. What does this actually mean? again, you don't need to bargain these things out. What I often do when I do this is, when I'm presenting proposals, I'll have, Article 6, and then I'll have the areas that are just stricken. And I'll note in there, or I'll explain when I hand it to the union, these are prohibited subjects. They're not proper for the contract, and so we're removing them from the contract. Question came in that says, Bob, what are you seeing in terms of trends in economic settlements? With savings from virtual learning and stimulus money, along with some counties passing enhancement millages, fund balances have grown with one-time money. Are you seeing a lot of on-schedule money in multi-year deals? That's a great question, actually, and it is it's interesting, right? I mean, I'm working with 2 districts right now as good examples in various stages of this. One is a deficit district who has done a lot of concessionary and freeze bargaining over the years, and is starting to try and give some money as they move forward here. And one of their problems is, because of all the one-time money, they're going to cut like $1 million off of the deficit this year. And so the union's going to think, well, great, look at all this. Look how much you're cutting out. You can give more to us as a result of it. But their whole thing is, yeah, but we're still losing students. So it's really putting a Band-Aid on it. And this is all one-time money that's going to be gone. So that's one. I have another district, as an example, where they're actually over their board goal right now on fund balance anyway. And because of one-time money, their 15% could balloon to 20% on their fund balance. And so with both, I think you need to think about where you're at and look at your strategy. Think about, okay, if you're in bargaining right now, for example, or you're in bargaining in the summer, a multi-year deal may be good just because you want to sort of get through some of this one-year money to figure out what reality is going to look like in 2 or 3 years. If you're in a good shape, that may be the situation. What I think is important, and that you also have to express to the unions, is that we have to be fiscally responsible. Just because we're over our threshold now doesn't mean we can spend it all now. This is one-time money, and if we're committing to on-schedule dollars, that's a commitment that lasts. This is money that's continuing on. So in terms of trends, yeah, I think I do see districts giving more money than they anticipated. But if you look at the last revenue conference, we're still talking about maybe not slashes as bad as we were thinking at one point last year, but and the revenue that we're getting is better than anticipated, but it's still down. So what is that going to look like? What is your student count looking like right now? And again, is the funding formula for this year kind of saving your backside from reality? And if we go back to normal next year, which is what the anticipation is in terms of how the funding is split, is that going to kill you? So you need to think about that and then move forward. In terms of what everyone's doing, it's always hard to say because that's going to be very, very different. But I will say I do think over the last couple of years there's been more money being given than there had been in a while. So that's going to vary quite a bit depending on where you're at. I do a good amount of bargaining, for example, in Macomb County. And in Macomb County, they passed a countywide millage. And that's going to last for the next 10 years. And so the unions have been chomping at the bit to get at that money. So your own dynamics are going to matter when it comes to the situation. All right, preparing for union tactics. I've been told sometimes that the word tactics sounds, maybe overly aggressive, maybe union responses. But I do think that these are oftentimes tactics that are used. It's part of the bargaining process. We need to understand them. We need to understand how to deal with them and know that these things could be coming, and know that these are just part of the process, right? So what are the union tactics? Well, typically the union has three sort of common attacks in the process. They attack the school environment, they attack school leadership, and they attack the school board in various different ways, right? So as far as the school environment goes, right, it's shirts and it's buttons, right? Everyone wears their red shirts on Tuesdays, kind of a thing. Balloons, tablecloths, handouts with key messages. You know, they end up involving the students. They talk about some of these things in the classroom. Maybe they talk about it with the parents in the bus loop. You know, nowadays, and this is kind of part of the school environment, kind of part of more of the community, but of course, social media is a huge influence nowadays in bargaining, with, you know, teachers and other folks putting messages out there on social media. In terms of the responses, you know, we don't want to ignore it, and we don't want to overreact to it either, right? Teacher says something to their kids. Kid asks why they're wearing their red shirt, and they say that, you know, it's a collective bargaining thing, or they explain it, and all of a sudden we say that's not appropriate for the classroom, and now we discipline them and give them 2 days off. Next thing you know, it creates a bigger stir than it would have ever been. So we have to, again, we don't want to ignore some of these issues, but we also don't want to overreact to it. This can be hard when we feel like sometimes that we have a good relationship with the union, because we can feel sort of like, wait a minute, I thought we were good. I thought we had a good relationship here. And so when that comes about, sometimes we can try and, you know, be friendly with them to solve it. But the reality is, this isn't about necessarily a personal relationship, and some of these things that happen, some of the maybe the attacks that have been made. All of a sudden, you get an email, or you see I just had a situation recently where, again, a bargaining that I'm working on. HR director, assistant superintendent sees this email that she's CC'd on to the Board of Education, where it really disparages her and her knowledge and these sorts of things. And that's hard to read because it's really a personal attack. And so, you know, what we don't want is to get bitter and then, you know, just go the same way, the opposite route. I believe in the idea of trying to stay as professional as we can while we, you know, do things that we can to counterattack, but think about how we do it and try not to just respond emotionally. It's important that we don't personalize what's happening. This can be common with principals. That's a hard one to be in, especially if they're on the bargaining team and they're working with the teachers and managing the teachers on a day-to-day basis. That's why I often think it's hard to have principals on the bargaining team at the table sometimes, because it can be hard for them not to personalize it, and for the union to personalize it against them or bargaining unit members. So the other point is they attack district leadership, right? I've seen no confidence votes against superintendents, spread rumors. The business manager doesn't understand us. HR hates us. You know, they're incompetent. The business manager doesn't even understand numbers and how they work. These are the sorts of things that you're going to hear, right? Publicize administrator salaries and benefits. Unions will often find ways to assert that the administration is doing well while the rest of the folks suffer. And so understand that could be coming as well. Think about how those attacks might happen in advance, right? And be prepared for them. Highlight, they will attempt to highlight any past or present competency issues. If there was some issue that happened, if an administrator who's on the bargaining team was disciplined a couple of years ago or at a previous district, that will come up. They will scapegoat the leadership to the board as the real problem. And if you have outside legal counsel or a chief negotiator, they will be attacked as well. They don't understand us here. They don't get the dynamic of our district. They're bilking the general fund while they're giving us nothing. These sorts of things will also be part of that problem. What can happen sometimes is We can do some problematic responses, right? There's the hero response. Well, okay, the superintendent hadn't been a part of the bargaining, but now the superintendent's going to come in and try and solve everything. Or maybe a board member, I need to be at the table to figure all this out. What that does is it shows the union that this is working and that they should continue the process instead of showing faith in leadership and staying the course. Now, this doesn't mean that when these things come up, we shouldn't be talking about them and talking through them behind the scenes. But a lot of this is important about what we show publicly and what we do at the table. We don't want to ignore the tax. We don't want to give in and cede management control to the union through the contract as a result of this. And we don't want to give away the farm in order to make it stop. This is a big reason why we need to be talking about these things in advance so that the board knows that this kid can be coming. So that way, when the time comes, they aren't willing to give away the farm. We need to continue to talk to them about the importance of being fiscally responsible and what it is. We don't want to necessarily deny that there's a problem. If bargaining is getting contentious, we need to address that. We need to talk to it behind the scenes, and we need to develop a communication strategy to talk about it in public as well. The finance director is, again, one who's often the focus of this. If you have a low fund balance, then they're incompetent. If you have a high fund balance, they're hiding money and they're untrustworthy, right? They're the uncaring sort of bean counter, right? So we need to think about those in advance and be prepared to address them also. Be proactive. Predictable and consistent process and methods show professionalism and help you get through this. Rely on your auditors. Be transparent in your numbers and talk through these things. That's an important thing to do and be honest about it and go through it. Otherwise, if you're trying to hide stuff, they're going to use that as a way to say that you're fudging the numbers or you're hiding money. The board is one as well. They will get sort of attacked in this process as well. They'll hear about this stuff at football games or at Meyer from community members. They will get it at board meetings, during public comment time. So again, even threatening, I've seen multiple times where they threaten to recall board members, run union candidates against the board members when bargaining is going on. So we need to understand that these are the realities of the process and move forward in there. One of the things that, again, this goes back to the point before about a fund balance. Oftentimes, the union response will be, "Hey, you have a fund balance. Let's spend it down." Right? I say spend to zero. Usually, it's spend it at 5% or spend to whatever the board number is. And we have to think about the short-term and long-term importance of that fund balance. Right? Consider adopting a board policy or at least a resolution that says, "Hey, we need a fund balance of 10% or a range of 8 to 12% or whatever the case may be for your district," and because then it allows you, when you're bargaining, to say, it's not, my hands are tied. I can't give you these proposals because if I did, it would put us below the threshold that the board has set, and then the board's not going to pass this. So we can't do it. So articulate that in terms of days of operation or potential loss as well, and what that looks like. Confronting common tactics, ground rules are a permissive subject of bargaining. I think it's okay to agree to ground rules on how bargaining is going to work, but I wouldn't agree to things in writing when it comes to ground rules. I don't like the idea of that. I think it tends to work against us more than it's going to work for us. And can lead to, some claim in a ULP later on that we violated ground rules. Understand strike threats can happen. and you've prepared the board for that, and think about how you're going to respond if it does happen, if bargaining is dragging on and you're starting to hear these sorts of things. All right. Last thing I'm going to talk about, I'm going to try and get through this quickly because I know we're about out of time, is a communication plan. I think the biggest key on a lot of this is being prepared and communicating with the board, with your community as a whole. So it's essential that the board understands the playing field and what's going on. The union is going to work to try and sort of win the hearts and minds of the community and of their bargaining unit members. And so that communication plan is going to be necessary to sort of address the problems and what is going on. So you need to be proactive in that, have a strategy, right? We want to frame the issues. I think it's always the usage of language is really important, right? I'll give you a great example of that. I'm bargaining in a district right now where they had given a concession years ago, and right now we're talking about, hey, well, we gave 4% last year, and now we're talking about another raise this year. And they say, well, you didn't give 4% last year. What are you talking about? That was just giving back money that you already took from us. But the reality is, if they got 4% more than the year before, that's a raise. So it's important to control and frame the communications. That goes at the table and away from the table. And if you've given money, talk about that. We gave this last year. We gave this the year before that. Here's what we've offered so far. Control that narrative. It's an extremely important thing to do because they're going to try and control the narrative in the opposite way to make you look cruel and stingy and that you don't care. And that sounds mean, but that often is the language used. So it's important that we control the communications. We have to be proactive in that because if we're reactive, they're going to get word out first, and we're going to be fighting from behind, right? Sometimes, right, they're not going to want us to lead the way on that because they're going to say, why are you starting this conflict? Well, we're not starting conflict. We're trying to collaborate through. We just need to make sure that everybody knows the facts and understands what's going on. Again, if you don't communicate effectively, your stakeholders they'll get first word out to both the board and to the community. And if we're always fighting from behind, it tends not to give us a good result in the end. All right, legal parameters. It's important that the employer provide factual report on status of negotiations directly, one that you can provide that directly to employees and by making public statements. Again, the union will often say that you can't talk about these things in public. But you can communicate proposals that have already been made to the union directly. And you can convey that directly to the employees or in other ways. I've had times where I've put it, for example, on the district's website, posted proposals. Talk about them at a public meeting and make them available to the public in different ways. And if you're talking about facts, which includes proposals that have already been made at the table, that is allowed. Employer may provide employees with a statement of its bargaining position, for example. I mean, it's often best to talk about this with the union first, but you can talk directly to the employees through a superintendent bargaining update or different things like that, where you're addressing these messages right to the employees. That is legal. You need to think about when and how, but it can be done. Good question that came in says, how do you get the union to understand that granting steps equals a raise? Steps can range from 2 to 7% from year to year. Absolutely. Right. And this goes back to, in part, the idea that steps, generally speaking, in the past have been thought of as automatic, right? So part of that is talking about it, right? Well, here's what steps are, and here's what they're going to cost. As far as that range, you may want to think about at some point, and I've been very successful in doing this in a lot of different districts, is creating a new schedule, a smooth schedule. Especially if you're in a position where you have money to give, there may be time to think about trying to do that so that all steps are fairly consistent. So that's one thing. But a lot of that is a lot of this communication is thinking through what you want to communicate and talking about it as much as you possibly can. Hitting these points over and over and over again. Well, we're offering steps, and that's going to cost the district $275,000 alone just on those steps. Talk about that. Bring it back again. When they talk about another proposal, well, we're already at $275 for the steps. Here's what that off-schedule money is going to cost. These sorts of things. Another question came in, says, what are your thoughts on one-time payments instead of raises or just small raises until we can see what enrollment will be and funding will be? I think it's a great idea. Generally speaking, unions don't like it, right? They want guaranteed on-schedule money. But depending on where your district is, off-schedule stipends of one kind or another can be helpful. One thing that can be good, if you do it as a stipend, there may be a way you can do it where you also save yourself retirement costs on that money. So that's another possibility. And while the union may not like that, what you can also express is, hey, look, if we're doing it as a stipend, as a bonus of some kind where we avoid retirement, it also allows us to give more than we could otherwise. So again, create messages, ideally in a contract, no more than like 3. We don't want to overload them. We don't want paragraphs of messages. We want bullet points that we can use and be consistent. And when I say be consistent, I mean talk about it often and early and often, right? In terms of what it is you're talking about. Repeat these in various methodologies. Don't just say at the table. Talk about it at the board meetings. Talk about it in communications to the people if you're getting messages out to your employees as well. We must establish trust, which comes with demonstrated competency and consistency. If we have a consistent message from beginning to end that we're using and we're hitting on, it makes us look like the responsible professionals in the room on this one. They may not like it, but at least we can do that. One point I think is important real quick on that, going back to that one. Provide training and crib sheets to key individuals in the district, right? So prepare your board, prepare the principals, some different people in terms of what those messages are so that they know what the messages are if you're working on a couple of thoughts and you're communicating them, so that when they hear about it in the bus loop or they hear about it at the football game, they know here's the things you can say. Because if they don't want to say nothing, here's what you can say, and have those for them. Again, consistency shows competence and understanding. Anticipate obstacles. Substantial time demands equal fatigue. Bargaining is going to get hard. It's going to get long sometimes. And sometimes the natural reaction is, I want to get this done. So fine, you know what? Just give them it. Give them that last time. It's important, especially if you're the chief negotiator, to understand these things and to hold steady as much as you can, right? Being consistent, communicating early and often with your stakeholders will help in these regards. And it will send that consistent message in the process, and it will make it so these votes of no confidence or these other things aren't as effective, because everyone involved understands what this is, that this is part of the process. All right, some parting thoughts real quick before we get out of here. The school reform legislation has significantly changed the playing field to our advantage. PA54, PA152, these things give us an advantage. So let's make sure we use them, right? Take clear and firm positions based on your economic condition. Don't just sort of work on what you think is appropriate. Have a plan and a strategy and why. Aim high and retain maneuvering room for mediation and fact-finding. Again, you don't start with your last and best unless, here's what I would say, here's the one caveat to that. If you're in a position where you need a 10% concession, what I usually work is I come to the table and say, I need a 10% concession, and that's my bargaining position every day until there's a contract, and I don't come off of that unless we're signing something. But otherwise, understand there's going to be some negotiation, some back and forth, and create room in the process for that. As much as you can, control the pace of bargaining, right? The union will want to control the pace as well. So work at your pace, and if you can, try and get them to work at yours, meaning how you make proposals, when you make proposals, these sorts of things, the methodology you use. Do your best to control that and remain in control, because it makes the process more understandable for you and makes you more comfortable in that process. They don't have to always follow suit, right? When I bargain, I do package bargaining, where every time I come to the table, I present an entire contract. Sometimes unions will fall in line and they'll do the same thing then on the other side of the table, and sometimes they won't. And that's fine. But here's how I'm going to do it. Here's the pace that I like to work at and what I want to do and move forward that way. Your goal should include, and again, you may not get there, but maybe include creating some leverage for next contract as well. Question that came in, should merit pay for teachers still be embedded within contracts? These are required by state statute, correct? Correct. So 1250 does require merit pay, although there's some limitation on how much we really use it. Should it be in your contract? It depends on how you're doing this. If you're in a situation, I talked to someone recently at a school district where they've gotten rid of steps and lanes entirely, and they have base wages and they have ranges, and part of that is based on merit in terms of where they go within that range. So if you're really going to get creative and overhaul things, and maybe you have, merit type considerations in your contract, but you really don't have to. Merit pay is a prohibited subject. And so that's something that you can make a determination on when it comes to board policy. So it's really going to be about, and this one does get weird because wages are a mandatory subject of bargaining. So it really depends on what it is you're doing. If it's just a matter of teachers who are rated effective get $500, in those scenarios, I think I would just do it through the policy rather than through the bargaining, because if you do it through bargaining, the union will get credit for it from your people, and if you can do it in the policy, you're the ones who are going to actually get credit for it, right? You're the ones who are giving them this money. It may not understand. It may not be anyone's fault that a contract isn't settled. Sometimes these things take time, and our need to sort of find someone to blame isn't always required. The community will support the board if they understand your position, right? They are naturally going to have more contact with the teachers, and they're going to feel more connection to the teachers. So that's why it's important that we communicate our position early and often. The school district can survive and even be improved as a result of negotiations, even if protracted, so long as, again, we're doing this in a responsible and professional manner, and understand, and even though it may not feel like it, the contract will eventually be settled. That's all I have for now. Thank you guys for coming along. I apologize. I had to rush through some of the end there from a timing perspective. I got caught up a little bit early But I really appreciate you guys being here for this. And I have my information here, my email and my phone number. If you'd like to reach out to me at some point, I know you can have the PowerPoint as well. So I'd love to hear from you guys if you have any questions or thoughts afterward.
Yeah, and Bob, we appreciate you, especially on a lovely Tuesday in February.
Thanks.
So, everyone, this is Kelly Powers with Muskegon ISD and a MNA board member, and really want to thank you for being with us today, and really want to thank Bob for, providing this as we, I think with our pandemic year now, it's been the craziness. We kind of lose sight of some of the bargaining pieces that are still there, and a lot of us are getting ready to, or are already in negotiations. So this was great, Bob. Really appreciate it, and appreciate the folks from Miller Johnson helping us out today. One thing, everyone, on behalf of MNA, we do have coming up February 18th. We have another program, which is the status of COVID, which is the employer-employee provisions, and that'll be at 11 o'clock. And we have Kara Rosen from Clark Hill working with us on that one. I hope you can join us there. And going to sign off. And again, Bob, thank you so much for all your help and support with the Michigan Negotiators Association. And I wish everybody a great day.
My pleasure. Thank you, Kelly.